over 500,000 South African households having installed solar, Eskom says that you must register your SSEG system before the 31st of March or face consequences. Now, recent press releases and videos, OUTA says that you don't have to, and Eskom may be overreaching. So who's right? Well, in today's episode, we're going to break down what are the actual laws, who are the responsible authorities, what's mandatory, what's debatable, and whether or not you should register your system. Welcome to the Utilities Decoder. Now, before we jump into the technical insights, we first need to understand some of the terminology such as SSEG, ERA, and PV/BES. Now, SSEG stands for Small Scale Embedded Generation. This refers to small generations such as rooftop solar and installations that are typically under 100 kVA connected to the distribution network. ERA is the Electricity Regulations Act, which determines the powers of the electricity regulator. PV/BES refers to solar systems with or without battery systems, and grid code are the regulations regarding connecting a private network to a public network. So what is Eskom saying? Eskom's media statements state that all small-scale embedded generation systems under 100 kVA must be registered even if you do not export power. They further state that if you register your system before the 31st of March 2026, registration fees for systems under 50 kVA will be waived, saving you up to 10,000 Rand. Now, they reference the ERA, NERSA rules and grid code requirements, and their argument is that the registration protects grid safety, technicians, public safety and network stability. But is this really the case? Especially if we consider that most modern day households will have systems under 50 kVA. So what's changed since October 2025? Previously, installations had to be signed off by an EXA registered engineer. Now, a Department of Labour registered installation electrician may sign off your installation and issue you with a valid certificate of compliance. The three main documents that are required for an SSEG application are a COC, which is issued by the electrician, a NRS 097 inverter test certificate, which is issued by the inverter manufacturer, as well as a commissioning test report, which is issued by the installer. Now, this sounds simple, so why the big debate? Well, OUTA is of the opinion that if your installation is behind the meter, it has a COC, and it does not export power to the grid, it complies with the Occupational Health and Safety Act as well as the SANS 10142 standards, then Eskom or municipalities may not have the authority to demand additional registrations. They've also raised concerns about the threatening letters, fines and administrative overreach, and feel that these may be challenging to enforce. So what does the law actually say? The three key frameworks involved in this debate are firstly the Occupational Health and Safety Act. Now, the Act defines safety on all premises as well as the requirements for safe installations. The compliance with the Act is issued in the forms of a COC. Secondly, we have the Electrical Installation Regulations. This is a section within the Occupational Health and Safety Act which defines how installations are to be conducted and refers to the SANS 10142 standards. These standards require certification by a certified electrician. Thirdly, the ERA. This defines the powers of the electricity regulators and governs generation, grid code and licensing. Now, the debate comes around whether the ERA gives Eskom the ability to require additional certification for non-exporting residential customers. So what did industry expert Chris Yelland have to say on the matter? Chris Yelland is of the opinion that NERSA, Eskom and municipalities do not regulate safety and technical requirements on private networks. Safety and technical requirements on private networks comes from the Occupational Health and Safety Act as well as the SANS 10142 standards. Therefore, this is the jurisdiction of the Department of Labour. An accredited electrician is registered with the Department of Labour and will then issue you a COC provided that your system and installation meets the requirements of the electrical installation regulations as well as the OSHA and SANS 10142 standards. Therefore, he is of the opinion that should you be in possession of a COC, your system is deemed to be safe and meets the requirements. He further stated that the ERA specifically excludes installations which are safe and compliant under 100 kVA. So where does this leave us? Well, experts agree that safety and compliance is mandatory. A COC is non-negotiable, and if you're exporting to the grid, you need to register your system. So what happens if you don't register your system? Eskom's disconnection messages have been softened, however municipalities remain aggressive. The cost relief expires at the 31st of March in 2026. So this begs the question, if your system is safe, compliant, non-exporting and behind the meter, are you planning to register it? Leave us a comment below. Let us know. Have you registered? Do you plan on registering? Are you going to refuse completely? Or are you waiting for more legal insight? Stay informed, stay efficient, and thanks for watching.